Thank you very much. And next, I would like to introduce Advocate Nomalanga Sithole, who is the CEO of NERSA, as well as the member of the Electricity Subcommittee. Advocate Sithole, may you please activate your camera and do your greetings if you are able to.
Good morning, Chairperson. I think my camera is frozen. It doesn't allow to open. But let me greet you and the members and NERSA colleagues and everyone else who have joined us for the public hearing. Thanks.
Thank you very much. Next, I would like to introduce another member of the energy regulator, the chairperson of the FIC and the member of the Electricity Subcommittee, Ms. Tembeka Semane. Ms. Semane, may you please activate your camera and do your greetings.
Morning, Chair, and morning to colleagues and also the members of the public.
Thank you very much, Madam Semane. I would like to also introduce the member of the Electricity Subcommittee, Mr. Muzi Mkhize, who is the member primarily responsible for petroleum pipelines, as well as the member of the Electricity Subcommittee. Mr. Muzi Mkhize.
Greetings, Chairperson, to all, as well as to all in attendance. Apologies. I'm struggling with the activation of my camera. I've been trying for some time. Maybe Gerard could also assist whilst the public hearing continues.
Thank you very much. It's all the full-time members. Actually, I don't know. I was not aware that it needed some permissions, but it's the same challenge. We apologize for that, but we're hoping that the attendees on the platform will be able to recognize the voices of the members that were unable to activate their cameras. As I have now introduced the members of the subcommittee, and I have also welcomed everyone to the public hearing, I just want to confirm that this public hearing focuses on the merits of the request made by Eskom for a temporary amendment to the Samancor Ferrochrome Limited NPA that was previously approved by NERSA, and secondly, for the NPA between Eskom and Glencore-Merafe Chrome Venture, Ferrochrome Smelters NPA, in terms of the take-or-pay terms that are contained in those NPAs. The public hearing that we are having today was duly advertised in the Business Day, Sunday Times, Cape Times, as well as Mercury, and it was also advertised in the NERSA website and the media platforms of NERSA. This public hearing is held in accordance with the provisions of the Energy Regulator, of the National Energy Regulator Act of 2004. Of which provisions are requiring NERSA to consult the affected parties and give them the opportunity to state their views and present facts that are relevant to the application that has to be considered by the energy regulator. The hearing is governed by the NERSA rules on public hearings, and these rules are summarized as follows. We want to stress that all parties that will be required to make their presentations, that they will do so under oath. And also the presenters that are going to make their presentations are allocated 20 minutes each to make their presentations, except for the applicant. In this case, it will be Eskom, as we would like to get a more clarification and critical aspects of the matters that are before us. Only the members of the panel may ask questions to the presenters. However, we do allow the members of the public to ask questions through email and send those questions to publichearings@nersa.org.za. Then the members will look into the questions that are posed by the members of the public and decide how those questions can be put to the presenters to get clarification. Should presenters wish to present information they consider to be confidential, please inform the panel so that the panel can decide whether they will still want to hear that confidential information during this hearing. If they do, then the panel may decide to close the hearing so that they can hear the confidential information. The audio recording of this public hearing, which is recorded by the microphones, will be the official record of this meeting. In terms of the House rules, the meeting of this meeting would like to request that all of the members of the public and those that connected to the platform must make sure that their cell phones are switched off or are put on silent mode. And please do not activate your video unless you are the presenter and you are requested by the chairperson to do so. And also would like to make sure that the chat is going to be used responsibly. We have only 2 requests for presentations today. The first request is from Eskom and Ms. Mutsabi Mokhatla from Eskom will give us a presentation. At this point in time, I would like then to invite Eskom to give us the presentation. Can you please activate your camera, Ms. Mokhatla?
Good morning, Chair, and good morning to all the members and members of the public who are here. As introduced.
Just hold on. Just hold on. Remember, I indicated in terms of the rules of the public hearing that before you give us your presentation, you will do so under oath. So I just need to check with you if you have any objections in taking the oath.
No, chairpersons. I would request that myself and the subject matter expert, Damesh Bana, who will be taking us through the presentation, be taken under oath simultaneously, if you do not mind, chairperson. Thank you.
Thank you. I'll do so. May you please raise your right hand? Okay. Do you solemnly declare that the evidence you're going to provide to this panel will be the truth and the whole truth?
I do.
Thank you very much. Please state your full name and your designation at Eskom for the record.
My full name is Mutsabi Mokhatla. I'm the Senior Manager, Retail Business for Mpumalanga region.
Thank you very much. May I then invite your colleague to also step forward so that I can do the same? Can you shift for your colleague, please, Ms. Mokhatla? Ms. Mokhatla, I'm waiting for your colleague.
Morning, Chair. Apologies for the delay.
Okay, I am unable to see you. I have to see you before we proceed.
Okay, my camera is on.
Okay, all right. May you please raise your right hand? Do you solemnly declare that the evidence you're going to provide to this panel is the truth and the whole truth?
I do.
Ms. Mokhatla, can you please mute yourself? Otherwise, this is going to cause problems for our record. Thank you very much. May you please, Mr. Bana, state your full name and your designation at Eskom for the record?
It's Damesh Bana. I'm a Chief Engineer, Eskom Distribution in the Office of the Group Executive. Thank you.
Thank you very much. Thank you very much. You may deactivate your camera for now, and then I would like to invite Ms. Mokhatla to start with your presentation. The time is now 09:43.
Thank you very much, Chairperson. I hope it was not a bit of a nightmare to toggle between 2 people, but I would like to take this opportunity to just thank Nelsa for allowing us to present. As indicated, I won't waste any time. I will allow my subject matter expert, Mr. Damesh Bana, to go through, and I'm here as a support. And I also want to say in the background, we also have Jenny Bartman, who works very closely with Mr. Damesh Bana in terms of putting together this NPAs, and they've got extensive knowledge in terms of that. With that said, Chairperson, if you will allow me, I will get off and then allow Mr. Bana to continue with our presentation. Thank you very much.
All right, thank you very much. Please, you can go ahead with the presentation. Can you beam it on the screen, and please start with your presentation.
Thanks, Chair. I will do so. Please advise when it's visible. Thank you.
Yes, it is visible. Just put it on presentation mode. Yes, it is now correct. You may proceed.
All right, thank you, Chair. So yes, as introduced, this is Eskom's application to NERSA for the temporary amendment for the take-or-pay terms for Samancor and for Glencore-Merafe in terms of the NPAs that have been approved by NERSA. So I've just got 2 slides, Chair. In terms of the background, so these NPAs have been approved by NERSA. These are 6-year long-term NPAs for Glencore and Samancor, approved by NERSA in October 2023. These were implemented for 6 years, commencing 1 January 2024. The ferrochrome sector, or the industry, is a key strategic sector in South Africa, and their smelting facilities are mainly located in rural areas where local beneficiation and economic activity are critical. The chrome ore, which is processed by the smelters into ferrochrome, mainly used in stainless steel, and South Africa has 70 to 80% of the world's chrome ore reserves. And I think our customers may elaborate more on that as well. Since last year, Q4, the ferrochrome commodity market price has declined significantly, and this is due to an oversupply of ferrochrome globally. It's further exacerbated by the Chinese ferrochrome smelters, who have put substantial product into the market, and hence driving the price significantly lower. These smelters further are subsidized significantly within China in terms of electricity pricing as well. The view is that the global demand ramp-up is expected to be slow in terms of recovery, and therefore one of the options is to have a supply-side response, which is basically a cutback in production to try and remove some surplus capacity that is in the market. Both our customers, Samancor and Glencore, have issued notices in terms of the hardship that they're currently experiencing, and this is as per the contractual terms of our NPA. This hardship is due to the reduced ferrochrome commodity price and the NPA, which requires a minimum consumption payment based on 70% of their normal consumption. So, Chair, if I can refer you to the letter which NERSA issued in terms of the approval of these NPAs, point number 6 in the letter indicates a minimum consumption payment based on 70% of their normal consumption, which is payable by each of the smelters. It's applicable for both Samancor and Glencore, and it's measured over a calendar quarter for each of these smelters and adjusted for any demand response. So that is the approval that was granted, and that is the waiver that we're looking at requesting against this requirement. So as I indicated, both customers have indicated it's unaffordable to produce ferrochrome under these current market conditions, and complying with the take-or-pay requirements above will significantly impact on the sustainability and long-term viability of the ferrochrome operations. If I move on, Chair, to the request, it's a temporary waiver of the take-or-pay requirement. We have, as Eskom, submitted written comments to NERSA's consultation paper, and Eskom's view is that NERSA may have misinterpreted the request in terms of the take-or-pay contractual condition versus the qualifying criteria in the framework. The qualifying criteria in the framework, which refers to the 80 gigawatt hours, I think it's clause 7.4. So we just want to highlight that point. What Eskom submitted in our application to NERSA is a relaxation of the take-or-pay requirement of 70% for 6 months, either from, at the time it was either from 1 April or from a date approved by NERSA. And the customers will have to select one of two options. The first option being it will allow them to continue producing ferrochrome, and the 70% take-or-pay will be measured rather at the group level and not at a smelter level. So if you combine all the smelters that are approved on the NPA, the customer would have an option to still meet that 70% requirement. However, this would be assessed at the group level. This would allow them to elect which furnaces or operations they would produce ferrochrome at, being more efficient ones, etc. The second option is a waiver of the take-or-pay requirement, complete waiver of that requirement at the smelter or plant level. And selecting this option would require a customer to switch off the full capacity at that nominated smelter. So that waiver would then apply for the requested period of 6 months. Once again, NERSA's interpretation of the request is a waiver of the 80 gigawatt hour qualifying criteria, which we believe is misinterpreted in terms of the long-term framework instead of the quarterly take-or-pay requirement, where I reference point number 6 in the approval letter. The take-or-pay clause does require customers to consume at least 70% of their normal consumption on a calendar quarter basis after any adjustment for significant events. So we would do adjust that for things like plant failures, maintenance outages, and demand response. Just going back to the 80 gigawatt hours, it typically takes these customers less than 2 calendar months to consume 80 gigawatt hours. So if we look at their current furnace operations, which are significantly energy intensive, they already comply with that framework requirement for this financial year of 25-26, 80 gigawatt hours. So that is not the request being made by Eskom. Should NERSA support the waiver, we propose that it be made effective from 1 July 2025. Chair, in concluding, Eskom supports the request for the waiver, a temporary waiver for the take-or-pay conditions for 6 months on these NPAs. Not granting this waiver for Samancor Chrome and Glencore-Merafe will significantly impact on the sustainability and long-term viability of ferrochrome operations in South Africa. The risk of termination of NPAs may jeopardize the return of ferrochrome production capacity and result in the loss of electricity sales. Chair, that's the presentation from Eskom. Thank you.
Thank you very much, Mr. Bana, for the presentation. Let me then invite, if you can make sure that you have a pen and a paper so that you can take down the questions of clarity from the members. I would like to now invite the members to ask questions of clarity from the presentation and from the application. Starting off with Mr. Mkhize. Please go ahead, sir. You are on mute, Mr. Mkhize. You can unmute yourself.
Oh, thank you very much, Chairperson, and thanks to Kgatla for the presentation. I'm just not so clear as to how has NERSA misinterpreted the take-or-pay clause, because it is interlinked with the load factor, which then makes it a contractual obligation. Just want to get that clarity. And two, the assessment at group level instead of plant or smelter level, just to understand its interpretation of what the framework requires in that regard, and why then would we deem it proper to go either way. And lastly, in terms of any impact that are negative, diverting away from the benefits envisaged in the framework, if we're to stick to what is provided there, who will then bear those negative consequences? Is it Eskom, or will this then find this a way and be diluted in the bigger customer base, or they'll be borne by either Eskom or the client, in this case being the smelters? Just want to get that clarity and certainty. Thank you.
Thank you, Mr. Mkhize. Madam Samane.
Thank you very much, Chair, and thanks to the Eskom team. From my side, I just have 2 or more questions of clarity. I just want to understand, in terms of the market share that the South African chrome smelters have, does it mirror the reserves? Do they have 70 to 80% of the market share? That's the first one. Or if it is different, then if Eskom can just advise in terms of that. Then my second one is my understanding correct to interpret what the smelters are trying to do, which is, to me, is like they want to reduce production so as to create scarcity in the market in response to what China is doing? Thanks.
Thank you, Madam Samane. Advocate Sithole.
Thank you, Chairperson, and thanks to the presenter. Chair, I just have one question of clarity to Mr. Banner. On slide 2, he has cited NESA's decision that was taken, which clearly indicates that the approval by NESA was done at individual smelter level. And I just heard him talking about grouping, or rather the waiver that is being sought will be based on grouping the consumption levels of the smelters. Is that interpretation based on his presentation correct? I just wanted that particular clarity from him. Thank you, Chair.
Thank you. Thank you very much, Advocate Sithole. May I just add on the questions? With regards to what Eskom is requesting, that there be a relaxation of the take-or-pay requirement. I just want to understand, and maybe this is something that Eskom, as an applicant in this case, should have tried to locate that request within the provisions. Yeah. No, Kayambata, please mute yourself. Walter, can you please assist? Walter, can you please assist?
I'm on it, Chair.
Thank you. Eskom as an applicant, I think it is important with the way that you framed what is required, that you link that to the criteria and the requirements of the framework, so that we can be able, as the regulator, to make an assessment of whether that linkage is indeed something that we have jurisdiction over. Because it is one thing for you to request that there be relaxation, however, you are not explaining how what you are requesting, how NERSA could grant what you are requesting in terms of the powers that are given to NERSA in terms of the framework. Mr. Mabunda, may you please mute those that are not supposed to be talking? Can you please mute Mr. Kayambata, please? That is the first question. So just in terms of jurisdiction and whether NERSA has powers, and under what provision of the framework is that provided. The second thing that I would also want to understand is the issue of I'm sure my colleague has already touched on it, but I just want to rephrase it just for my understanding. Eskom is talking about the minimum requirements stipulated in the framework, the one on the minimum consumption, as well as the load factor. Now, Eskom is proposing that instead of looking at the individual plant, that this be looked at a group level. I would like to understand, how is that going to be done in terms of the provisions of the framework? Is it something that NERSA is empowered to do in terms of the framework? If so, which part of the framework empowers NERSA to consider the minimum consumption on the basis of a group? Meaning that the aggregated consumption as opposed to the individual consumption, and also aggregated load factor. Where is it provided in the framework? Can you assist us with that so that we can be able to ascertain whether we have jurisdiction to entertain that part of the request? The third thing that I would like to understand is the duration of 6 months. Given the fact that in terms of your motivation, the necessity to come up with this temporary intervention is market driven. It is something that is happening in the market, making it difficult in terms of the demand for the smelters to meet the required consumption. So it is really something that perhaps will still be corrected by the market. Now, I would like to understand, how did you arrive at 6 months and not 1 year, for instance? What market information guarantees that the market conditions that give rise to this commercial challenge or the economic conditions would have been restored by the market within 6 months? Where is that information? If you can assist us with that so that we can understand the duration, and that duration must be substantiated by the market conditions. What are the current market conditions? What is the forecast of the market conditions that will therefore improve such that this intervention will not be required in beyond 6 months? Where is that? I think for us, it is important that we get that information. And then the last point that I just want to understand is the situation at the smelters currently, given the fact that you will require that the intervention commences on 1st April 2025. What is the situation currently? How are the smelters complying with the conditions that were part of that NPA as approved by the energy regulator? Thank you very much. If you can assist with those questions.
Thank you, Chair. I'm going to attempt to respond to the questions. Where we are unable to respond, Chair, we will revert with a response in writing, if that's okay. Chair, the first question in terms of the interpretation from NERSA for take-or-pay, load factor was mentioned, and the 80 gigawatt hours. Chair, whilst they might be related because they all are linked to energy in some form or the other, there are different parameters or criteria. The 80 gigawatt hours is our understanding in terms of the framework, a criteria for customers in terms of qualification for the NPA that they consume on an annual basis at a minimum of 80 gigawatt hours. And as I referred to in my presentation, these customers within 1 to 2 calendar months would meet that requirement. So that's not the relaxation we're asking for. Neither is it for the load factor, which the framework refers to as 70%. Chair, what we're asking for is in terms of the framework where it does refer to some level of demand certainty that the customer should provide. And in our submission and application for NPAs to NERSA, we concluded a 70% take or pay, which is measured on a quarterly basis. So what that does, Chair, is it commits the customer to consume at that level based on their capacity of their plant, that they consume at least 70% of the energy they would normally consume at full production. And that is measured on a quarterly basis, 3-monthly basis, that they meet that requirement. So this is linked to demand certainty within the framework to try and get a commitment from the customer that they will consume some amount of energy on a quarterly basis, that the customer doesn't switch in and out in terms of production capacity to follow whatever the case might be, a market trend or etc. And that Eskom realizes sales over the period at a consistent level. So this is what we're referring to, the take-up pay 70%. It is linked to demand certainty within the framework, and it was in our submission and approval in terms of the conditions that was granted by NERSA. So that's in response to the first question. The question around the impact on the negative impact of sales and the consequences. Chair, yes, that was the intent of the take or pay, to ensure we get those sales, consistent sales. The negative impact of allowing a temporary waiver or relaxation, yes, it will have an impact on Eskom sales, resulting in reduced sales over the period of 6 months. Eventually impacting on, obviously, the revenue requirement for Eskom and, I guess, end of the day, the end customers. Eskom views this as a temporary relaxation to try and protect this ferrochrome sector so that in the longer term we can achieve the sales that are required. Our view is that if we enforce this requirement of 70% and they are unable to produce within this environment, Samancor and Glencore may opt to terminate this agreement and potentially shut down permanent capacity in terms of ferrochrome production. So in the shorter term, yes, we might take some pain in terms of reduced sales, but in a hope that we can sustain this industry in the longer term. In terms of the
on that one, Mr. Banner, did you do an analysis to NERSA to show that impact? Because you've asked for a period of 6 months. So if that relaxation were to be granted, did you then submit information on the impact analysis so that we can at least have a better understanding of the revenue shortfall, and also in terms of the sales that were expected, and so that we can also have an understanding on the customers, because that should also be part of the considerations by the regulator when it makes the decision. Can you assist us with that?
Chair, we may have not specifically provided numbers in terms of the waiver for 6 months. It would also depend on what option the customer chooses, but we can give indicative values if required of what that revenue or sales shortfall would be. And just to highlight, Chair, to the committee that, if we do enforce that we continue with this requirement, just remember the customer does have an option of terminating the NPA and completely switching off the plant as well, and Eskom will not get any sales. But we can provide that information if required, yes. In terms of the market share, Chair, no, we haven't done any research or analysis in terms of whether the 70-80% chrome reserves translates to market share globally. I think our customers can maybe elaborate on that as well when they present in terms of the global market share. Yes, and the question around reducing production, was that to reduce the oversupply? Yes, it is to reduce the oversupply in the market. There's a question raised. The approval at individual smelter or grouping of smelters, and whether that's in the framework. No, Chair, the framework is not as specific as that, and does not refer to this type of request that has been made. But the reason why Eskom's made this request in consultation with the customers is that it allows us to maybe or possibly minimize the impact of the loss of sales if you allow for grouping. The potential here is that customers could move production between their furnace operations, those that are more efficient than others, and still possibly meet the 70% requirement. In that way, we can potentially save the loss of sales. So that's where the grouping comes in from. And where the customer is unable to group the smelters together in this nature, then the individual request of waiver at smelter level. So, Chair, there's no specific reference in the framework that would highlight such a requirement.
What will be your submission then? What will be your submission then for the regulator to consider this type of a request then? Under what section, or how are we supposed to look into this type of a request as the regulator? Because we do want, if you bring something like this, obviously we work on the basis of a framework. It is important, therefore, to substantiate your application on the basis of the framework. Now, it is important that you make a submission to the regulator, a submission that must, that the regulator, that you will point out that the regulator is empowered. That the regulator is empowered. Can you please mute a bit? Please, there's some people are talking on the background. If you can kindly assist the regulator in understanding how are they supposed to consider your request if you are saying that the framework does not specifically provide for a demand uncertainty or the consumption at a group level. So how are we going to consider that request from Eskom if you are saying as an applicant, it is not specifically provided for in the framework?
Chair, so the framework has qualifying criteria, has guidelines in terms of NPAs and how these should be structured. And the one we referred to is demand certainty. And in our negotiations with the customer, using the framework as a guideline, we then go into negotiations and try and put forward a package or a pricing agreement that we submit to NERSA in terms of those interpretations of the requirements of the framework. So the demand certainty indicates, as I stipulated earlier, to try and commit a certain level of sales. And we've articulated that in our submission to NERSA as a 70% take-or-pay requirement on a quarterly basis. So there's various conditions and requirements which we've then articulated as an agreement, and we've submitted that to NERSA, and NERSA's approval was in terms of specifically then those requirements. So not per se reference to any particular clause that would make that requirement or clearly articulate that requirement. So what I'm saying is our interpretation from the framework, its requirements result in an application to NERSA with a proposal. And that proposal was supported in this case by NERSA, and that's the clause that we're referring to. So all I can say, Chair, is it's reference to the demand certainty clause within the framework. In terms of the grouping, as I said earlier, no, the framework doesn't specifically state whether there's grouping of consumption allowed or not. But it's a request that we're making in terms of what was approved by NERSA, if that could be a consideration.
Okay, remember that as an applicant, obviously the regulator should not be struggling in finding the grounds for your application, and also for the regulator to struggle in trying to ascertain whether we have jurisdiction to entertain your request, especially on the grouping. And also given that in some of your applications before the regulator, you have indicated the importance of looking at the individual points of supply and ensuring that the cost that are incurred by Eskom for individual points of supply are taken into consideration and should not be aggregated or grouped. So that is also something that the regulator will have to also take into consideration. That's the first thing. And the second one is whether when you support or you're making that proposal of an aggregation, whether that is going to be the approach that Eskom considers in other applications, other NPA applications, not only in respect of the two applications that are before us. So it is important for certainty and predictability to understand, the consistency of Eskom in considering circumstances of customers that come to Eskom or for NPA. If you say that, let's not consider individual plants, let's consider the consumption at a group level. Is it something that now is going to be a consideration by Eskom with others as well, or only in respect of these two customers? I think that is also something that you may need, even if you don't respond to it today, but it needs some clarity so that we can understand how Eskom deals with these kind of applications going forward.
Yes, thanks, Chair. Maybe a brief response. It was in Eskom's view that by allowing or the grouping of these smelters to meet that requirement would protect some of the sales. However, Eskom's will take direction from NERSA. If it's only at plant level, that's approved. That is something Eskom can accept. There's no issue on that. In terms of future applications, as I said, there's nothing in the framework that guides along the lines of group or no group. Eskom will submit application based on the negotiations at the time, and these most likely will be at individual plant levels, not at group level. So this is an exception in terms of the request. Chair, the duration, 6 months. From our experience of this market, it is of a cyclical nature, with prices fluctuating over periods. The view we had that 6 months may be sufficient to provide some relief, and we did not want to extend it beyond 6 months to impact on sales either. So it was a view that Eskom took that due to the cyclical nature of this sector, that possibly 6 months would provide the relief that is sought. And if it didn't, then Eskom could possibly revert back to NERSA to extend that. But going further than 6 months would definitely impact on sales. And we thought this is to minimize the risk in terms of sales that we do request for 6 months. Chair, I think I may have covered all. If I've missed one, please advise.
Yes,
there was a
did.
question around 1 April 2025 and how they're meeting their current requirements. As I
Yes.
said, the 70% requirement is measured on a quarterly basis. So they're still within that quarter. We only assess that requirement at the end of the quarter. So currently, the smelters are still in production, and they are awaiting the outcome of this decision from NERSA to make a call in terms of how they then reduce production at the various facilities going forward, if approved. Thanks, Chair.
Thank you very much. Can we understand, because there's a bit of a challenge here in terms of what is being requested. You are putting options. You are asking that NERSA approves sort of an open-ended situation here, because you have put options. You are not applying for a specific intervention that you believe is going to work. So you want NERSA to approve the options, and then the customer can decide which option is going to be suitable for its circumstances. Can you clarify really what is it that you want NERSA to approve, that you are motivating for, instead of putting options? Which option is it that is going to work and deal with the challenge at hand?
So, Chair, the option or the request is one request. It is in terms of the approval for the NPA that the 70% minimum take-or-pay requirement for a quarter be applied. So that is the waiver we want. In terms of how we implement, that's the two options that we propose, that you could either request that at group level that they meet the requirement, or that we then waiver it at plant level. So the request is in terms of the take-or-pay 70% requirement. That is the request, Chair.
Right, thank you very much. Let me check if members have any other question that they would like to ask before we then release Eskom. Any question, member? It seems all the questions have been exhausted. Thank you, Eskom, thank you very much. Thank you, Eskom, for your presentation. We also thank you for your time. Ms. Mukhatla, I take it that you don't have any additional points? Ms. Mukhatla?
Apologies about that. I was trying to get Mr. Banner to mute. It took him a long time. Thank you very much, the chairperson and the committee members. We really appreciate the opportunity, and we are also open to any other further details that can be required. We can send anything that is required over and above that, but we appreciate the opportunity to present. That's all that we have for today. Thank you very much.
Thank you very much, ma'am. Thank you, Eskom, for your time. We now go into the second presentation, and this is a combined presentation from Samancor Chrome as well as Glencore-Merafe Chrome Venture. We've got the names of Setat, Yapi Fulat, and Amanda Macro. Hoping that I've pronounced them correctly. May you please activate your cameras? Those that are going to make the presentations.
Good morning, all.
Okay, good morning. May you please indicate which one is this?
Good morning.
Is it Amanda?
Yes, correct. I'm Amanda Margrove from Glencore.
Good morning,
Okay.
Chair. My name is Stef van Sidert, representing Samancor Chrome.
Okay, all right. Let me then start with Amanda. Amanda, may you please raise your right hand? Do you solemnly declare that the evidence you're going to provide before this panel is the truth and the whole truth?
I do.
Thank you very much. Please state your full names and your designation.
Amanda Louise Morgan, and I'm from Glencore-Merafe and Crown Venture.
Thank you very much. We now go to Steph van Settet. May you please raise your right hand? You can mute yourself, Amanda. Thank you. Do you solemnly declare that the evidence you're going to provide to this panel is the truth and the whole truth?
I do.
Thank you very much. Please state your name and your designation for the record.
Stefanus van Settet, CTO, Samancor.
Thank you very much. Do we have Yapi Fullard?
Yes, good morning, Mr. Chair. Yapi Fullard. I'm not sure if you can see my camera.
Okay, it's Miss. I'm Miss. All right. May you please raise your right hand? Do you solemnly declare that the evidence you are going to provide to this panel is the truth and the whole truth?
I do.
Thank you very much. Please state your name and your designation for the record.
I am Jacob Pieter Minnaar Fullard, and I am the CEO of Glencore Alloys.
Thank you very much. I don't know who's going to start with the presentation, but it is also important that in the way that you are going to present, we do want to have an appreciation of the facts that are peculiar to each of the companies. In as much as you are trying to consolidate the presentation, it is also important that you empower us with the crucial factors that will enable us to appreciate the challenges that are faced by each company and at plant level. If you can try and do that as you go through the presentation, please.
Thank you, Mr. Chair. Yes, I will then begin. I will do the first portion of the presentation, and I'll also give feedback on already some of the questions, if that is okay, just to put a bit of light onto some of the questions. Would that be okay?
It will be okay, yes, in anticipation of some of the questions we have already posed to provide clarification. Thank you.
Thank you. Thank you, Mr. Chair. And then also, I just want to understand, we did forward the presentation. If it's possible, would it be possible to flag it, or do you want me to share?
May you please share? If you are unable to, I will then request Mr. Walter Mabunda to assist from our side, to beam it from our side, but please share it from your side.
I'm just trying quickly. Just want to understand if you can see the presentation or not.
Yes, I can see it. Please try to put it on presentation mode.
Yes, do that. Just want to understand. Just want to know if you can see it.
Yes, I can see it. You may start with your presentation. Thanks. Time is now 10:28. Thank you.
Thank you. Okay. So first of all, there was a specific question with regards to the market share of South Africa versus the Chinese. And I can confirm that between ourselves and Samancor, we produced in the region of 3.6 million tons of ferrochrome last year in 2024. And in the same year, the Chinese ferrochrome industry has produced 8.9 million tons. So you could see that it's quite a substantial move in terms of ferrochrome production into China versus South Africa. I think it's also important to note that we've got about a combined capacity in South Africa of, let's say, 4.8 million tons. I'm going to touch on Glencore specifically. So during 2020, you would know that we have put the Lynenburg complex under care and maintenance. That was a full furnace operation. And then unfortunately as well, we then also had to put Rustenburg smelter under care and maintenance last year. And this was even in a time period where, as it was noted, that we did receive the MPA already from the 1st of January in 2024. So even with the MPA value that we did get, it just still shows that we are in real trouble in terms of production. I just want to know if you can still hear and see me, because we just got a power outage.
Yes, I can still see you and also the presentation.
Okay,
Thanks.
thank you. Thank you for that. So just in terms of timeline, I think it is important. I will go through the timeline and then I'll go through into the detail why it is that we are in a hardship period, ourselves and Samancor, in terms of beneficiating chrome ore into ferrochrome. I'm also sure, Mr. Chair, that you know that only us and Samancor are integrated ferrochrome producers. So that means that we mine our own ore and then we convert our own ore as well. But we also buy chrome ore from other producers, primary producers in South Africa. We also use UG2, which is a byproduct from PGMs, and so for that reason we then convert. I did tell you that we've got about capacity of 4.8 million tons of ferrochrome capacity in South Africa, and we only produced 3.6 already last year. So you can see that there's a decline even in our own ferrochrome production. Coming back to this slide, this is just the timeline in terms of where we are. So in 2023, we did, NERSA did approve a 6-year MPA. Samancor had 6 complexes, and the Glencore-Merafe venture had 5 complexes. And like I said, out of the 5 complexes, Glencore in itself only has got 3 complexes left, which is Boshoek, Wonderkop smelter, and then also Lion smelter. The MPA was then implemented on the 1st of January 2024. And like I said, because of the subdued price, we were not even in a position to start up Rustenburg smelter, even under the MPA conditions. Then by the end of 2024, there was a sharp decline in the ferrochrome conversion spread. And I'll touch on the next slide in terms of conversion and what that means, because I'm sure that the panel will ask, but why is it that we are not converting chrome ore into ferrochrome in South Africa ourselves if we've got the chrome ore in South Africa, and why do we export all the chrome ore? I can also tell you that quite important factor is that last year South Africa produced 27 million tons of chrome ore. And also a bit of facts, I think it is important to just put it into context, is that for every 2 tons of chrome ore that you mine, you convert 2 tons into 1 ton of ferrochrome. And so out of the 27 million, we then have converted in the region of about 7 million tons into that 3.5, 3.6 million tons of ferrochrome. And we have exported out of South Africa 20.5 million tons of chrome ore. That obviously is going to China, most of it, and they then converted that into ferrochrome in China. So and for that reason, that's where that sharp decline in ferrochrome conversion spreads really started, to hit us. And for that reason, when we went into 2025, almost like the 1st of January in 25, we have seen that there's even a further decline in the spread, in the conversion spread, and I think it's a very important concept, and I'll take a bit of time there as well. We then notified Eskom in terms of clause 6.2 of our MPA in terms of the hardship clause, and we know that Samancor also, together with Glencore, have issued those notices. Obviously, then Eskom approached NERSA, and because of the MPA requirement that we've got, and that is that we've got our MPAs per complex, and you must then at least use 70% of that electrons during that quarter. You must then use those electrons, and because of the fact that we cannot do that anymore, we then gave Eskom the notice, and then Eskom also approached NERSA, and then, as you know, NERSA then arranged for that meeting, and then the public consultation comments that was due on the 10th, and today is on the 28th of May, and that's the NERSA publication, and that's where we are. And ultimately, as per the NERSA communication, the public decision would have been the 24th of July of 2025, but as also stated by Eskom, and Eskom asked if it's possible that we can have a decision by the 1st of July, and we would definitely support that if it's possible that NERSA can consider this waiver by the 1st of July and not by the 24th of July, because it is quite important for us in terms of our quarterly conversions. Just in terms of this slide, here, what we do here, or try to do, I think it's very important that we all understand this graph, but this is the conversion margin that it is all the other costs associated to convert chrome ore into ferrochrome, taking away the ore cost. So what we do is we take the ore cost out of the equation, because that is a very important factor, and then we look at what is it in terms of conversion where we convert versus the Chinese. And you will see that the conversion margin from January 2023, and you'll see it comes already from there, you'll see that in terms of, and it's been expressed in cents per pound, and you'll see that what's starting to happen is that the ferrochrome conversion spread is coming down tremendously. And that is because in China, the reason why there's such a huge amount of ferrochrome that's been converted in China is, first of all, their electricity price is most probably half of South African electricity price. Then obviously their cost of capital is much, much cheaper. They've got a return on capital employed in the region of about 3%, where, as you know, any business in South Africa or in the world requires at least a 10 to 15% return on capital employed. So they've got a very low capital base. And then thirdly, their labor cost is also much more or much cheaper than us. And another important cost element would be their reductants, and their reductants are also much cheaper than us. So if we compare our our conversion spread in South Africa versus the Chinese, you will see that it came down all the way from, let's say, 49 cents per pound, and it's currently in April 2025, it dropped down as low as 28 cents per pound. And that's the main reason why we are not competitive. So if we make ferrochrome in South Africa, we cannot make it cheaper than the Chinese. Because remember, like I said, we strip out the chrome ore price, and then we only look at that conversion margin. So I'm not going to go through all the the detail here, but I'm sure there will be some questions on this. So what does this then mean for us in terms of thanks, PJ. I'm going to stop sharing because there's a updated presentation, and I'm going to ask PJ Gray to start sharing. So if you don't mind, we did update this one, if that's okay. So PJ, please, if you can then share that for me, please, if you don't mind. PJ, I just want to know, is this now your presentation?
Great, thank you.
Thanks for that. So what does this mean in terms of the hardship situation and actions taken by industry? It's not like we as South Africans have just sat back and did nothing. Now, if you have a look at this graph on the left-hand side, that is what they call the global cost curve. And just to put it in simple terms, that you'll see that there's a dotted line, and that is the global ferrochrome price. Okay, so that is your cost curve price. So all the companies, and you'll see that there's a host of bars that shows that the different companies or that different regions in terms of the ferrochrome production, and all the ones that's below that dotted line are in money. So that means that the cost of production is below that cost curve line. That means that's the selling price. So it just makes sense then to understand that everything below makes money and everything above that dotted line is out of money. Now, you'll see that there's the yellow, and all the yellow bars are all the South African complexes. That means Samancor and Glencore jointly staggered in terms of efficiencies, in terms of technology, and that's why you'll see that some of them are still just under that bar, but most of them are above that bar. And for that reason, you will see that all the ferrochrome smelters in South Africa, most of them are out of money. If you compare it to the rest of the world, that big black bar that you see underneath the line, that is Inner Mongolia. And we all know that Inner Mongolia currently are sitting with a RMB price of between 35 and 40 RMB. So they are much, much cheaper in terms of electricity prices versus us. If you then have a look at also that cost curve in terms of the ore and ferrochrome pricing, that's the one that's also to the left-hand side. You can see that the big difference between ore prices versus ferrochrome prices. So that red line is the ferrochrome price, and how did it just drop down all the way, and also in terms of comparison towards chrome ore. So for this reason, we are obviously, by selling the ore, remember I told you that we sold 20.5 million tons of chrome ore out of South Africa, and even with that, that's why there's such a massive difference between the ferrochrome conversion versus the chrome ore. what did we do as South Africans? Obviously, Amanda, that is also part of the panel. She's the Chief Operating Officer of Glencore, responsible for all the smelters. Over the last couple of years, we are continuously looking at improving our efficiencies. We are pushing out more and more tons. We've got cost cutting across all the operations. We've got internal resources. So what we do here also is we manage our maintenances. We use our own employees now. Nowadays, I mean, I told you that we closed down the Rustenburg smelter, and we then use internal resources well. And all of this is to try to make our ferrochrome industry in South Africa competitive. We have also looked at our capital projects. It's on hold and in certain instances cancelled. So it's also on a cash preservation plan. And then also what we've done, and Eskom would know this, we had multiple sessions, Eskom, with the government, with a host of governmental bodies, all the ministers, the DTIC, the DMPR, the Minister of Finance, also the Minister of Electricity. So there's multiple interventions that we had in terms of stakeholder engagement. We've spoken to the unions in terms of support. And I mean, I'm sure there could be a couple of questions in terms of what did we do on top of this. But all in all, in a nutshell, this is the reason why we came to Eskom to say that is it possible that we can have the hardship clause. And I can tell you now that there's the two options, the ones of clustering everything together. So as you know that we've got MPAs per complex, and one of the requests is to put everything together so that we can manage that better. And then the second request is to just waive the take or pay in totality. And I can tell you from a Glencore perspective, and I'm sure Samancor as well, option one would not be an option for us. So if we cluster everything together, that is not going to work for us. We can't make it work as the industry. And if that's going to be the case, we will most probably have to then terminate, the MPAs. So only option two would be viable, and Amanda and Steph will take us through the reasons behind that. I think that's the last slide for me. PJ, you can go to the next one. Thanks. Thank you. Thank you, Mr. Chair. I'm going to go on mute, and I'm going to then ask Steph to just take us to the next couple of slides, and then Amanda, the last couple of slides. Thanks.
Thank you very much. Thanks.
Thank you, Yapi, and thank you, Madam Chair. For reference, I think I'm going to talk about the take or pay provision, and I think a bit of alignment of understanding is important. So I'm going to take the panel through our understanding of the provisions of take or pay in the NPA. So the minimum quarterly consumption per plant in kilowatt hours is calculated based on the 70% of the normal quarterly consumption in kilowatt hours. And the normal quarterly consumption is calculated by adding up the relevant 3 months normal monthly consumptions, taking into account factors such as the notified maximum demand, the load factor, which is fixed under the NPA, the power factor per site, which is fixed under the NPA, and then obviously the hours in the month. So I think it's just important, based on the discussions and the presentation by Eskom, that the understanding of the take or pay and the minimum 70% is clearly aligned. Next slide, PJ. So with that, obviously the challenge for both ourselves and Glencore is the fact that during a severe and prolonged market downturn, the liability for us remains that we will be billed at the minimum quarterly consumption, which is calculated as per the previous slide. And, during this market downturn, one of our reactions would be to curb supply in order for the market to restore. And, during this time, obviously, we have requested hardship under the NPA agreement. And so adding the penalty or take-or-pay penalty during this time will just further put us into a position where we ultimately need to terminate the NPA and also the supply from Eskom, impacting Eskom revenue permanently. We've also illustrated the quarterly adjustment periods below in this slide. And I think the significance here is also linked to the discussion around when the decision will be made by NERSA to implement the amendment if so decided. So it gives you an understanding of the importance where we enter into Q3 and Q4 during the 1st of July, and we need to make certain decisions from an operational point of view, taking us forward under the NPA. Thank you, PJ. Next slide. So this will be the last one for me, and then I'll hand over to Amanda to go through a bit more detail between the two options. But I think as we understand the Eskom submission is that Eskom submission includes for two options in a temporary nature. Option one, which we have discussed a bit, is the evaluation of take-or-pay on a group level. And option two refers to the evaluation of the take-or-pay to remain on a smelter level, but allow actual consumption to be below minimum quarterly consumption, or suspension of a particular smelter or smelters for that period. We also want to emphasize that, in our view, the minimum qualification or the 80 gigawatt hour per annum NPA qualification requirement is not directly linked to this request on the take-or-pay amendment. And I think that was further elaborated by Mr. Bana in the Eskom presentation previously. So concluding on this slide, the temporary suspension of the take-or-pay provision will allow for the temporary suspension, not closure, of individual furnaces or smelter complexes, which we think is in the best long-term interest for local beneficiation, job retention, and obviously Eskom revenue quite linked to the South African economy and growth of the economy. So from Samancor's side, I just wanted to give you some clarity and alignment on our understanding of the take-or-pay provisions and the submission from Eskom side and aligning thereof. And I will now hand over to Amanda to take us through a bit more detail under options 1 and 2. Thank you, Amanda.
Thank you, Steph. And again, thank you for the opportunity. I will briefly run through our understanding of the two options that is currently on the table, just to ensure that we are on the same page. A lot has already been said on how Samancor and Glencore are operating our smelters. We've got different complexes, and each of those complexes have their own individual NPA. As per option 1, we will then look at collectively complying to the terms of the take-or-pay obligation. So ensuring that overall, amongst the different complexes, that we comply with the minimum overall consumption that is stipulated. The smelters will then be obliged to operate and consume the minimum power. So even if it is combinedly so, we need to meet the minimum threshold. And the relief is obviously, as mentioned, up to a period of 6 months. So after the 6-month period, we will revert back to the individual compliance to the NPAs, and then that is the one option. Alternatively, we will maintain suspended or limited operation and just comply with the take-or-pay liability. And in event that where we cannot do it, it will ultimately lead to the termination of the individual NPAs to avoid the liability in terms of the take-or-pay. So this is an inflexible option for our smelters, especially considering all the hardship that we are currently under, and as explained by Mr. Yabi Fuller. So the other option, as we understand it, is in terms of option 2, where we currently look at the industry that's in distress. So temporarily suspend the provisions of the take-or-pay liability and allow us some time to seek alternative interventions that will allow us to resume all operations after a 6-month period, and then commence and ensure the sustainable production of ferrochrome in South Africa. Obviously, the next 6 months will be vital for our industry in seeking these alternatives. And if these alternatives will not be available, we will enter into further discussion and potentially terminate these NPAs. But again, if we do have these interventions, we can resume operations at all of the complexes and maintain the take-or-pay liability as stipulated in the agreements. So in conclusion, for us as Samancor and Glencore-Merafe operations, we prefer to go with option 2. It will allow us some time to seek short-term interventions and also engage with government in terms of the longer-term sustainability of smelting in South Africa. I think there is a conclusion and key consideration. We have been exposed to this take-or-pay liability already for the biggest part of 6 and more months. And as per the current provisions, and by the time that there's a final decision, a couple of more months would have passed and definitely negatively impact on the sustainability and the long-term viability of ferrochrome smelting in South Africa. So key for the survival of this industry is that we at least grant the 6-month period where we suspend the take-or-pay liability and allow operations to seek alternatives. And at this point, I would like to hand over to Yabi Fuller to take us through to the final notes. Thank you.
Thank you. So I think that's quite clear. Is that from our perspective between Samancor and Glencore is that we are in severe hardship, and for that reason, we did speak to Eskom, and we did say that we would like to waive the take-or-pays, and I think it's clear also why is it that we opt only for option 2, and that will allow us in the next 6 months to really work hard with government, as Amanda said, to see if we can't get that conversion spread, the one that I showed you right in the beginning, if it's possible that we can make that conversion spread smaller so that we can compete with the Chinese. I think ultimately that is what we are requesting. I think, Mr. Chair, I'm going to pause here and obviously allow for clarifying questions, if that's okay.
Thank you very much for the presentation and for clarifying in detail what you are requesting and what necessitated this request and the predicament that the industry or these two companies find themselves in. Thank you very much for that. Let me now turn to the members of the regulator to ask questions of clarity. Members of the regulator, by show of hands, if you can kindly ask questions of clarity from the presentation that we have just received. Okay, maybe I can start from my side. I just want to understand as the nature of this market is such that there's, there are these cyclical changes in the market which impact the demand. What if the market turns dramatically after 3 months? Will that automatically suspend this relaxation that you are seeking? And then you revert back for the next quarter? What will happen? I mean, I do take the point that you have made in the presentation that, these evaluations on the take or pay that are done on a quarterly basis, you feel that it is not sufficient. The period is too short. I do understand that point that you have made, and your wish is that maybe the evaluations could be done, over 12 months or just over 12 or during the period of 12 months or more. Just to understand what will then be the situation if the market changes dramatically after 3 months. Will that then suspend the relaxation? I think that is the first question that I would like you to clarify. You have touched on the on your preferred option, which you can confirm whether it is indeed option 2, which is the temporary suspension of the take or pay to avoid liability under the NPA. If then this option, first of all, maybe confirm that this is your preferred option that might then address the economic hardships that you are experiencing. If you can kindly confirm that first. And secondly, to then apprise us of the impact that will be resulting from the temporary suspension. If we're to allow the temporary suspension, what will be the effect in the market, but also maybe if you look broadly to your supplier of electricity, in this case, Eskom, what will be the effect of that? If you can kindly respond to those two questions. But the other issue that I really wanted to check with you is on this issue of the high cost, because that is something that is within your control in terms of being the high cost producer. I do take note of the other sort of cost cutting and efficiency measures that you have taken into consideration. But what other solution that you believe could assist the two companies in improving its competitiveness in the global market? Those are the three questions that I would like you to respond to. I'm hoping that you have taken them down, because we also have other members that are going to ask questions, and then you can respond to all of the questions. I would like to now hand over to Mr. Bukula. Thank you.
Thank you, Chairperson. Chairperson, I only have one question. If option 2 is chosen, I think it then means that the associated revenue the revenue from the associated sales will be lost. And if that's the case, I will still then operating within the NPA framework, because the NPA framework requires this revenue. I mean, it gets approved so that you preserve those sales and all of that. Thank you, Chairperson.
Thank you very much, Mr. Bukula. Going to Mr. Mkhize.
Yeah, thanks, Chairperson, and thanks to the presenters led by Mr. Flood. I just had a challenge. Maybe I could have lost at some of the points, but from my side, I look at the essence of the agreement, that there are certain goals that are being sought to be achieved. And therefore, I think it's very important, for example, to say, if you no longer have that 80 gigawatt hours per annum, then it then could be defeating the purpose of having entered into the agreement in the first place. And I think that a more detailed explanation of the impact, or analysis of the impact of that kind of a deviation would mean, and how this could be done over a longer period, maybe to still amount to the same thing, to the same threshold. So if maybe we look deeper into that, and how then there can be a sharing of between the supplier and the client of that loss, if there is any loss that is then resulting from that kind of a deviation. I'm not finding that very clear. And then also from my side, I think it's also going to, I just wanted to get some clarity. If we're saying that we're looking at a group level, are we saying that we're looking at a group level such that the average still remains 80 gigawatt hours for the whole of the plants combined? Just wanted to get that clarity, and not to say that as long as the one plant is producing, is consuming that 80 gigawatt hours. Just to be sure that I understand them correctly. Thank you.
Thank you, Mr. Mkhize. May I now request Samancor as well as Glencore to respond to the questions from the members. Thank you.
Thank you. If I can perhaps go and just clarify a couple of points. If we do have the option of option 2, it means that we are requesting the waiver of the take-or-pay per complex for a certain period. And what happens if the market changes dramatically? Then 100% obvious we will then start up again. I mean, if we see that there's a demand or change in terms of our cost versus the Chinese cost, or that conversion spread is of such that we can be competitive, that will immediately mean that we will then start up. I also do believe that, remember, we are asking the waiver of the take-or-pay of the 70%. So it could be that if we get this right, that some of my complexes can now operate at 50% or even at 25%. If I think about a Lion complex, I've got 4 furnaces at Lion. So if I do get a relief, and option 2 is the one that we are going to take, let's say, and it's been approved, it means that even from a supplying the rest of the world, which means outside of China, it will allow me to still operate under the MPA condition, but only at 50%. So that means it's better for Eskom in terms of revenue, and it's better for us in terms of a business, because we can still then sell our ferrochrome profitable, if that makes sense. So 100% of that. So although we can waive it, but it will be always better for South Africa to restart. I mean, that's what we want to do. So that's just on the first question. I hope I clarified that. What will the impact on the ferrochrome production be? I mean, obviously, if we are going to go for option 2, we will, because of different technologies, as you know, we will then most probably stop certain of our complexes for that period in terms of the take or pay, and in that case, we will then be better off in terms of not making a loss. Then the other solutions that we are looking at, I can tell you that we are investigating other, let's call it, solutions out there as well. I'm sure that most of you would know that there's other technologies that's been discussed over the last while that we are also, as Glencore specifically, are investigating to see if we can't be more competitive. So definitely we are looking at that as well. But I can tell you that in the meantime, and that's the reason for us coming to Eskom to say, can we please have a take or pay waiver on option 2 specifically? Why is that? Because currently, as we operate using all the electrons, we are losing a lot of money, and we are actually burning cash. So we are not in a position to be able to use the electrons to convert ferrochrome into chrome ore. That then comes to the one that there was a question on how is it possible, because you didn't hear this coming through, is how can we share the cost or the loss? Let's say sharing the loss. We unfortunately are not in a position to share any losses. We can't, and that's the reason why I can tell you now, and this is not, this is, I think, public knowledge. That's why we did pull the trigger on our hardship clause, and that hardship clause is very clear that if we do not get the relief, we will terminate the NPA. And whenever we are in a position to restart, because if I terminate the NPA, it means I will terminate ferrochrome production at certain of my operations. I mean, that's why we did ask Eskom for relief, because otherwise we are going to terminate. I can tell you from Glencore perspective, I can't speak on behalf of Samancor, but from Glencore perspective, we will definitely terminate our NPA at certain of the complexes if we do not get relief. Amanda, if you can then perhaps talk about especially the 80 gigawatts, and also how does that play out? Thanks.
Thank you. Maybe just for clarification, there was an earlier question on the industry and who is determining the price, etc. I just want to highlight that between us, Glencore and Samancor, we are the South African ferrochrome industry. We are the only role players currently in this country. The production in China is exceeding what we are producing. So currently they are the price makers, and that is also the reason why we sit in this predicament. In terms of the revenue loss that Eskom will incur if we do not consider the take or pay agreement, like Yapi rightly mentioned, we can actually go then on and terminate these agreements, which in any case will mean a loss to Eskom or a revenue loss, and potentially a revenue loss in the long term, and not only for a 6-month period. As we all know, once you've decided to close down a smelter, it's not that easy to recommission it if you do not have the proper plans in place. With regards to the 80 gigawatt hour that was mentioned, it's not representing our actual consumption. That is the threshold to actually qualify for an NPA. So that is not reflective of the consumption of us and Samancor. And like we've mentioned, the relief is set for a period of 6 months. and to ensure our long-term sustainability of smelting in South Africa. So long-term loss will be far-reaching for Eskom if we do not get this option. It will simply mean the termination of the NPAs. Thank you. Steph, over to you.
Thank you, Amanda. Maybe just would like to add on the minimum qualification, the 80 gigawatt hours question. I think, as also mentioned by Mr. Bano from Eskom, this relief is for a 6 months period. The 80 gigawatt hour per annum, most or all of the sites will consume that within a 2 months period. So you know, this will certainly not be an issue and won't be triggered. And in our view, as mentioned, not linked to the take or pay or waiver of the take or pay provision as such. And maybe just from a Samancor point of view, you know, and touching base on the revenue loss of Eskom, I think it's important to note that for the first year of the NPA 2024, Samancor Chrome produced record ferrochrome production due to the NPA. And during that time, shared upside with Eskom above the minimum pricing level. So there was upside at that point for Eskom. If you know, this provision or suspension of provision, you know, is not successful, as both Amanda and Yapi indicated, you know, could result in termination of NPA, and that would result obviously in much bigger revenue loss for Eskom. As you know, for example, Samancor consumes about 4% of Eskom's generation capacity. So you know, it will be quite significant on the Eskom revenue line. Thank you, Madam Chair.
Thank you very much. Just two quick follow-up questions. This duration of 6 months, how confident are you that the market will restore? If you can just clarify for us. And that is not to suggest that it should be increased, especially if it's going to affect Eskom's revenue. And obviously that is a risk, and it's something that should be avoided. But I do want to get some clarity as to how certain are you that the market will be able to recover and stabilize so that the prices are able to strengthen and come to some levels that will sustain your business.
Yeah, so thank you, Mr. Chair, and I think that is an extremely valid question. And I can tell you now that the market will not restore within 6 months if there's no intervention from government. I just want to make that clear. And for that reason, we are in a huge amount of discussions at a very high level with government to make sure that we put interventions into place to make ferrochrome production in South Africa sustainable. It's only us and Samancor that is producing ferrochrome in South Africa. And I can tell you, I was in China last week, and they are building more and more and more capacity. So I can sit here today and I can tell you that the 6 months period or grace period that we are requesting is a grace period so that we can do something with government to get intervention. Because if you have a look at that other slide, and PJ, I'm not sure if you can again put up the slide, but if you have a look at that conversion bar or that conversion margin, since 2023, January 23, all the way up to now, it just went on and on and on. It's just getting smaller and smaller and smaller. There you can see it. Just go back to that one. Yes, that one. I mean, there you can see that over time, if we are not going to do something, the 6 months period is not going to help us. The 6 months period grace that we're asking, in terms of the hardship clause, is to see what we as SA Inc. can do to make ferrochrome viable in South Africa, if that makes sense. And that is the hard truth. So I can't tell you that if we terminate ferrochrome production in South Africa, that all of a sudden we are going to see a spike in the ferrochrome price. Because that's the only, and I think that question was asked to me, will we start up if we see a spike? The only thing that can happen is that there must be a change in the way that we do things, because between ourselves and Samancor, we've done everything that we could in terms of efficiencies, in terms of driving our ton per tons and all of that. So there is no short-term solution except if it comes from government at a very high level. If that makes sense. I'm not sure if there's a follow-up on that.
Yes, there is a follow-up, and the follow-up is what has been mentioned during the presentation, that you might have to consider reducing output, output restriction. And I was wondering, to what extent would that influence the prices outside of South Africa by the South African ferrochrome industry? Is there any way that you could influence the prices if you were to reduce the output? Or is it going to be something that you will work with other companies outside of South Africa so that there is a sort of a coordinated effort to reduce the output so that prices can begin to rise?
Yeah, Mr. Chairperson, I'm not 100% sure about what you mean reduce the output. I mean, if we get this clause, that the take or pay clause waived, the chances are very good that we will most probably close down most of our ferrochrome production from Glencore's perspective in South Africa. Now, so we will stop the outflow of ferrochrome. I can tell you now that we've got already so much ferrochrome already in stock today that we cannot sell, because if we sell it, we are making even bigger and bigger losses. So we will definitely terminate, or we will definitely suspend operations if we do get this clause or this waived. So I think that's very important to note that. But what government needs to do, and this is not up to us, we can't, from our perspective, stop the outflow of chrome ore. We can't do that, because that's where our revenue comes from. But clearly the government are in a position, or must be in a position, to do certain things. And what they can do is obviously give us an MPA price that will make sense, that we can be competitive towards China, or there should be other interventions. But we can't go and negotiate with people outside of South Africa. I mean, there's no ways that we can do that. We are not privy to that. So I'm not sure if I answered your question, but I see Amanda also perhaps also want to just add.
Yes, so if we do suspend production in South Africa, that will definitely not have an impact on the price per se. That deficit in production will just be taken up by the Chinese producers. So it will not have a positive impact on price for South African producers. I just want to highlight that.
Okay, thank you very much. I think I'm answered also by Amanda. Mr. Mkiza, thank you.
Yes, just concerned about that recovery being put to be after in 6 months' time. Just the interventions from the company side, because all I'm hearing is government doing something. But I don't get, for example, the issue of the reductant prices, doing something concerning the coke from a reductant point of view. And then the issue of also newer, more efficient technologies, because my understanding is that there is no scope for that. I think there was another presentation when we were looking at it where this was highlighted. Does this now mean that there is now scope for that in the existing plant, or you're talking about when one looks at new technologies and new plants altogether? Just want to get the clarity as to what you are going to be doing meanwhile to ensure that, and taking the cyclical nature of the industry. I think whilst looking at this, is there no way that we look at a factoring of that cyclical nature of the industry into the agreement itself going forward? Thank you.
Okay, thanks. I'm going to quickly talk about the cyclical nature of the industry. That was 100% the case a few years back, is that we always have seen as the chrome price climbs, the ferrochrome price follows. That's the way that it worked over the last 20 years. That was up to 2013, 2014, when South Africa produced 90% of the world's ferrochrome came from South Africa. And we were in control of ferrochrome production in South Africa to the rest of the world. What happened is that ferrochrome production have shifted to China. So what happened is that you'll see, I mean, if you have a look at the last 5 years, is that there's a structural change. And the cyclic nature of ferrochrome prices going up and going down is no more. And you can see it again, coming back to the slide that's on this presentation, is that there's a squeeze all the way. If I take this slide back a couple of years, I'm talking up to, let's say, 2018, you would have seen going up, going down. But there's a structural difference that's now happening. And for that reason, if we do not do something, and I mean, you're 100% correct to say government, but I can tell you that from a investment perspective, it's very difficult to go and try to convince shareholders that we must invest in South Africa if we are going to just lose money. I can tell you that there is technology out there, and that technology can have a substantial difference in terms of your electricity per ton. So your megawatt per ton could be substantially lower, but we are busy with that and we are looking at that. But it's a medium to longer term solution that I can tell you that we are working at. So it's not going to solve our problem currently at all. I can tell you as well that Lion Smelter has got a megawatt, and I mean I can share this because it is not confidential information, but I can tell you that our electricity efficiency of Lion Smelter. Remember, Lion Smelter has got a specific technology, and it's got the best technology in the whole world. So when I visited China, their megawatt per ton is sitting at, let's say, the best one that they can do is 2.65 megawatt per ton. That's what they've got. We are below that if I have a look at Lion. So we've got better technology, but because they've got 50% cheaper electricity than us, they can convert cheaper than what we can do at Lion. So I just wanted to give a bit of context in terms of technology and what we're doing there. I mean, Amanda and her team, and Steph, I'm sure 100% also from your side. If I have a look at the last 5 years, 6 years that Amanda has been in charge of the ferrochrome division, I can tell you that our efficiencies, every month we're breaking records. We are getting better and better and better, but yet we are losing more and more and more. It's because of this whole shift of ferrochrome production from South Africa out back into China. That's where the big problem lies. I'm not sure, Steph, if you and Amanda want to just add to that, or is that sufficient enough?
In agreement. Thank you, Yobi.
I'm happy with that. Thank you, Yobi.
Thanks.
All right.
PJ, you can just drop the presentation again. Thanks, if you don't mind.
All right, thank you very much. I think we have exhausted the questions, and thank you for making the time to come and present and provide clarification to the members of the energy regulator in helping us understanding what is happening in the industry and understanding the options that that have been put before us and what could work for these companies. We have now come to the end, or just before that, maybe I need to then go back to Eskom and give them 3 to 5 minutes for their concluding remarks as an applicant before the energy regulator, just before we adjourn this hearing. Eskom, over to you. May I check if we still have Mr. Bana as well as Ms. Mukhatla?
Mr. Bana is still on the call, Chair.
All right. Eskom, may you please give your concluding remarks?
Thank you very much, Chairperson. We are here. I think we don't have much to add. As indicated earlier, if there are any other information that's required from our side to support our application, we are happy to do so, Chair. That's all what we have from our side. Thank you very much.
Thank you very much. We are hoping that during the questions, there are certain questions that could not, that Eskom could not answer. One of them that I can recall is that we requested Eskom to provide us with its analysis of the impact of the options. If we grant option 2, what will be the impact? They should be able to provide us with that information. That's just one piece of information request that Eskom has committed or undertook to provide in writing. So if they can just remember to do so. Just before I come to you, Mr. Fullert, I just want to confirm with Eskom. Eskom, are you?
Yes. Apologies, Chairperson.
Yes.
I did do a thumbs up. Sorry. Yes, right. We are aware of that. Thank you very much, Chairperson.
All right. Thank you very much. If you can kindly submit that information in the next 7 days, we will appreciate that. Thank you very much. Mr. Fullert, I'm not sure because at this point we just wanted the applicant, but we would not shut you out. Please go ahead.
Yeah, thank you. I really appreciate it. I just wanted to just make that point very clear that if we do get option 2, that it means that we will then waive the take or pay, but that will also mean that some of the complexes could be started or restarted operating below the 70% take or pay. We just want to make sure that if we can get that also noted, and that will obviously help. I mean, if we can look at the Lion complex and we can run it into such a way that it is below the 70, but we are still going to, to operate it, that will definitely assist both Eskom and also the businesses. So it is not only the suspension of the operations of the complex, but only the waiving of the 70%. So I just wanted to make that point, and that will also assist the question that was asked, but how can we duly share this loss? Just wanted to make that point. Thank you very much.
Thank you very much for that additional point. We'll take that into consideration. Ladies and gentlemen, we have now come to the end of this public hearing, and we would like to thank the presenters for availing themselves today and for providing a clarification to the questions that we have asked. and for providing detailed presentations for our benefit. I'm hoping that all of the presentations have been made available to NERSA, because that will assist us in terms of going back to the slides and understanding some of the points that we could not clarify during this hearing. Thank you very much for your time. I'd like to thank the members of the Energy Regulator for all of the questions of clarification, and thank the NERSA staff for ensuring that this hearing takes place today. The observers for taking interest in our in today's proceedings. We also thank you for being present and for making sure that the hearing goes on smoothly without any interruptions. We thank you for that. The hearing is now adjourned. Thank you very much. Members, we can meet on the pre-hearing link. Thank you.